Hi, this is Lee from the Law School Toolbox and the Bar Exam Toolbox. If you're planning to take the bar exam in July 2026 or February 2027, we need to talk, because the exam you're about to sit for is not the same exam that your older friends, your mentors, or your study group leaders took. It's not even close. The uniform bar exam is getting its biggest overhaul in decades. It's called the NextGen UBE, and it changes the structure, the question types, the timing, the grading, basically everything except the stakes. The stakes are exactly the same. So today I'm walking you through 11 things that every bar taker needs to know about the NextGen. Some of these are structural and some are strategic, and at least a couple might genuinely surprise you. So let's get into it. Number 1, and I'm leading with this because it's the thing that gets a big reaction when I tell people. The NextGen bar exam is only 9 hours long, not 12. 9 hours spread across 1.5 days. You test on a Tuesday, morning and afternoon sessions, and then Wednesday morning only. 3 sections of 3 hours each, and you're done by Wednesday lunch. Compare that to the Legacy UBE, which has 12 hours over 2 full days. That's a 25% reduction in total testing time. But here's the catch. The intensity per minute is a bit higher. Every section is packed with multiple question types, and there's no coasting. Each 3-hour section contains 40 standalone multiple choice questions, 2 integrating question sets, and 1 performance task. You need to manage your time across all of those within the same session. Number 2, the question types are completely new. Gone are the multi-state essay exam questions. Gone is the old-style multi-state performance test. What you have now are 3 categories of questions: standalone multiple choice questions, integrated question sets, and performance tasks. And before anyone says, well, multiple choice is multiple choice, not exactly. I'll get to that in a second. But the big shift is that the exam is no longer divided into separate components where you spend half a day on essays, half a day on multiple choice. Every 3-hour section blends all 3 question types together. And this is by design. The NCBE wanted an integrated exam that tests knowledge and skills together in realistic scenarios. So you might go from answering standalone multiple choice questions to reading a client file and advising on strategy to writing a portion of a legal memorandum, all within the same 3-hour window. Number 3, let's talk about that multiple choice wrinkle. There are 120 standalone multiple choice questions on the exam, 40 per section. Some of them are your traditional select 1 of 4 format, but some of them are a brand new format, select 2 of 6. So instead of 4 answer choices with 1 correct answer, you get 6 answer choices, and you need to pick the 2 that are correct. And here's the important part. Partial credit is available. You get credit for each correct selection independently. That changes your approach. On a traditional multiple choice question, you're using process of elimination to narrow down to 1 best answer. But on a select 2 question, you're hunting for a pair. You have more options to sift through, and the elimination strategy is fundamentally different. So my advice is practice this format specifically during your prep. Don't just assume your multiple choice skills will transfer. The cognitive task is genuinely different when you're evaluating 6 options and looking for 2 correct ones. Number 4, integrated question sets or IQSs. This is arguably the most novel part of the NextGen exam. An IQS presents a single client scenario and then asks you a series of questions about it. Think of it as a mini simulation of what you'd actually do as a first-year associate. There are 2 flavors. Counseling sets mix multiple choice questions, including the select 2 format I just talked about, with short answer questions. You might be asked to identify 2 facts that support a client's position, or to list 2 benefits of a proposed cause of action, or to assess the probable outcome of a motion, all centered around 1 fact pattern. Then there are drafting sets. These give you an actual legal document, a draft contract, a complaint, a lease, and ask you to identify problems with it and explain how to fix them. Or in some cases, you're asked to draft sections of a document from scratch. And here's a critical strategic point. Each question within an IQS is independently answerable. The answer to one question doesn't depend on getting another one right. So if you hit a tough component early in the set, don't panic. Move on. You can absolutely nail the rest, even if one component trips you up. You have about 24 minutes per IQS, and there are 2 per section. That's roughly 48 minutes of each 3-hour session devoted to these. Number 5, performance tasks. These are worth 30% of your total exam score. So let that sink in. Nearly a third of your score comes from 3 performance tasks, 1 per section, at roughly 60 minutes each. They come in 2 very different formats. Standard performance tasks, or PTs, give you a case file and a library of legal authorities, and you produce 1 extended writing assignment. It might be a portion of an objective memo, a persuasive brief, a client letter. The case file has all of your facts. The library has all of your law. It's a closed universe. Then there's the legal research performance task, the LRPT. This is something entirely new. The LRPT is a hybrid. You get the same case file and library, but before you write anything, you answer a series of multiple choice and short answer questions that test whether you can actually parse and understand the legal resources. Then you write a medium-length piece applying what you've found. The LRPT is really testing a different skill than the standard PT. The standard PT says, here's the law, here's the facts, now write. The LRPT says, here's a pile of legal materials. You can figure out what they mean, how they fit together, and then use them. It's closer to what you actually do when a partner drops a research assignment on your desk. So let me paint a picture of what an LRPT might look like to make this concrete. I've put together an illustrative example based on the format and style of the NCBE sample questions. Now, this isn't a real released question. It's an original hypothetical to give you a sense of the experience. Imagine you're a junior associate. Your supervising attorney sends you a memo. Your client is a small business owner named Carter who signed a commercial lease for a retail space. The lease includes an indemnification clause. Now, the landlord is demanding that Carter pay for injuries sustained by a delivery driver who slipped in the building's parking lot. Carter says he had nothing to do with maintaining the parking lot. That's the landlord's responsibility. Your case file includes 3 documents: the memo from your supervising attorney, a transcript of your interview with Carter, and a copy of the landlord's demand letter. Your library includes excerpts from the fictional Franklin Commercial Landlord-Tenant Act and 2 Franklin Appellate Court decisions that interpret indemnification provisions. Let's call them Baxter Properties versus Crane Distribution and Hillside Plaza versus Moreno Enterprises. Now, here's where it gets interesting. Your first component might be a select one multiple choice question, asking which of the following best describes the holding in Baxter Properties versus Crane Distribution. And your 4 answer choices each characterize the case differently. To answer it, you have to actually read the case in your library, distinguish the holding from any dicta, and pick the answer that gets it right. Component 2 might be a short answer question. Identify 2 specific facts from the client interview that would be relevant to determining whether the indemnification clause covers third-party injuries in common areas. You get 2 answer fields, 1 sentence each. Components 3 and 4 might dig deeper into the statute, maybe asking you to identify the operative provisions of the Franklin Act that define the scope of permissible indemnification in commercial leases, or asking you to distinguish the facts of the 2 cases from each other. And then the writing assignment ties it all together. You're asked to draft a portion of a memorandum to your supervising attorney, analyzing whether the indemnification clause, as written, obligates Carter to cover the delivery driver's injuries under the Franklin Act and the case law in your library. So notice the progression. The early components build your comprehension of the law. They make sure you've actually read and understood the resources. And then the writing assignment asks you to synthesize it all. But here's the key. Even though they build thematically, each component is scored independently. If you nail the multiple choice and short answer but run out of time on the writing piece, you still bank those points. Number 6, this one is huge, and I think a lot of people are going to overlook it. The NCBE content scope outline marks every testable topic as either starred or unstarred. That distinction should fundamentally shape how you study. Starred topics must be recalled from memory. You will not be provided with any legal resources for those topics. When a starred topic shows up on the exam, you need to know the rule cold. Unstarred topics, on the other hand, may be tested with or without legal resources. When they're tested with resources, you get the statute or case law you need. When they're tested without, you at least need to recognize that the topic is at issue. So the practical takeaway is you're going to have to go through the content scope outline and sort every topic into 2 buckets. The starred topics get the flashcards, the repetition, the memorization drills. The unstarred topics, you still need to understand them, but you should be spending more of your energy building the skill of quickly reading and applying unfamiliar legal authority under time pressure. That's a different kind of practice than traditional bar prep. It's less about pure memorization and more about developing fluency with reading statutes, parsing case holdings, and applying law to facts when you're seeing the law for the first time. Number 7, the NextGen tests 8 foundational subject areas: business associations, civil procedure, constitutional law, contract law, criminal law, and criminal procedure, evidence, real property, and torts. But, and this is important, other areas of law will also appear on the exam. Specifically, family law and trusts and estates are confirmed to appear on every administration from July 2026 through February 2028, and other areas may pop up too. Before you panic, you are not expected to memorize family law or trusts and estates for the first 2 years of the exam administration. Whenever these non-foundational areas appear, they show up in the IQS and performance task sections, and all the necessary legal resources are provided to you. This is actually a really important philosophical shift in what the exam is measuring. The NextGen is saying, we know you can't memorize every area of law. What we want to know is whether you can function as a competent lawyer when you encounter an area you haven't studied in depth. It's a real-world skill, and the exam is designed to measure it. Number 8, the grading system is completely different from the legacy UBE, and this actually works in your favor if you understand it. Here's how it works. For each legal issue in a writing assignment, graders score 2 things separately: your rules on a 0 to 4 scale and your application on a 0 to 4 scale. A 4 means accurate and thorough, a 3 means mostly accurate and thorough, and it goes down from there. And there's a separate assessment of what they call additional requirements. That's your organization, structure, audience awareness, and tone. If your additional requirements are satisfactory, your legal analysis score stands as is. If they're unsatisfactory, meaning your organization is so poor that it seriously impairs understanding, or you're writing to the wrong audience, your score gets reduced by 1 point on that issue. And every constructive response is double graded. 2 independent graders score each response, and if their scores are too far apart, the response goes through a reconciliation process. That's a significant investment in fairness and consistency. The bottom line, there's a transparent standard you can aim for. Your score doesn't depend on how well or poorly the rest of the country did. If you deliver accurate rules through application and clear organization, you earn these points regardless. Number 9, the NextGen is fully computer-based. You'll take it on your own laptop using NCBE's secure testing browser. And the digital interface is not just a neutral container for the questions, it's actually an important part of the testing experience. The platform lets you toggle between your case file and your library in a split-screen view. For performance tasks and LRPTs, you'll have multiple documents open: the memo from your supervising attorney, client interview transcripts, statutes, case opinions, and you need to navigate between them efficiently while answering questions or composing your writing assignment. If you've never practiced in that kind of digital environment, you're at a real disadvantage, especially on the LRPT, where you're literally toggling back and forth constantly. Getting comfortable with the interface before exam day is not optional, it's part of your preparation. The NCBE offers official study aids that use the actual exam delivery platform. Seriously consider investing in them, even if you feel confident about the substantive material. The goal is to make the platform invisible on exam day so you can focus entirely on the law. One other note, the exam software is designed to reduce the need for some traditional accommodation requests, which is a positive step toward accessibility. But if you need accommodations, check with your jurisdiction early. Those decisions are still made at the jurisdiction level. Number 10, score portability. One of the best features of the UBE survives the transition to the NextGen. Your official NextGen UBE score is portable, and the NCBE handles score transfers between participating jurisdictions. Scores are reported on a scale of 500 to 750, and each jurisdiction sets its own passing score within that range. So the mechanics are similar to what they've always been. But here's the wrinkle. From July 2026 through February 2028, each jurisdiction chooses whether to offer the legacy UBE or the NextGen UBE. They can't offer both. Starting in July 2028, only the NextGen remains. So step 1 of your bar prep is find out which exam your jurisdiction is administering for your target sitting. Don't assume. Check your jurisdiction's page on the NCBE website. And if you're thinking about score portability, meaning that you want to take the exam in one state and transfer your score to another, make sure you check the transfer policies for both jurisdictions. Rules and policies change, and the NCBE strongly recommends consulting the jurisdiction's bar admission agency directly for the most current information. Now, I couldn't just do a top 10 list. I had to have 11 items. And honestly, number 11 might be the most important thing I say today. The NextGen doesn't just test whether you know the law. It tests whether you can use it. The NCBE has organized the exam around 4 foundational skills groups. And if you understand these groups, it will change how you study. Group A is issue spotting and analysis, investigation and evaluation. This is the classic law school skills. Read a fact pattern, figure out what legal concepts are at play, identify which facts matter, assess the strengths and weaknesses of a position. If you've taken law school exams, you've been building this skill for years. Group B is client counseling and advising, negotiation and dispute resolution, as well as client relationship management. This is where you step into the role of the attorney talking to a client. You're advising on strategy. You're weighing benefits and drawbacks of a proposed course of action. You're identifying what claims to bring, what remedies to seek, and what terms to negotiate. And this is key. Group B is also where the model rules of professional conduct get tested. Those MRPC rules are tested from memory. There's a specific list you need to know cold. Things like competence, diligence, confidentiality, conflicts of interest, communication with represented persons, and candor toward the tribunal. They're tested within the IQS sections, not on the standalone multiple choice portion. So you won't see a standalone multiple choice question that just asks you to recite Rule 1.7. Instead, you'll be in a client scenario where a conflict of interest issue arises and you need to recognize it and respond correctly. Group C is legal research. It isn't about knowing how to use Westlaw. It's about your ability to work with provided legal resources, to identify what's authoritative, distinguish holdings from dicta, figure out whether a statute or case answers the question you're facing, and recognize when you have enough law to reach a conclusion. This is what the LRPT is specifically designed to test. And Group D is legal research and drafting, actually producing or revising a legal document, drafting a section of a memo, reviewing a contract, and identifying provisions that need to change, writing client correspondence. This is a skill that the drafting sets in the performance task writing assignments are measuring. So here's the practical takeaway, and I want to be clear about this. If your study plan is 100% focused on memorizing black letter law, you're training for a fraction of what the NextGen actually measures. You also need to practice advising a hypothetical client on whether to settle or go to trial. You need to practice reading an unfamiliar statute cold and identifying its operative provisions under time pressure. You need to practice reviewing a draft contract and spotting the 3 provisions that conflict with your client's goals. You need to practice writing a clear, organized analysis that addresses the right audience in the right tone. The NextGen is testing you like a first-year associate, not a law student in a final exam. So adjust your prep accordingly. Okay, let's wrap it up with a quick recap of the 11 things we've learned. 1, it's 9 hours, not 12. 2, there are 3 question types, no more legacy essays. 3, the select 2 multiple choice format changes your strategy. 4, integrated question sets simulate real lawyering. 5, performance tasks are 30% of your score and come in 2 flavors. 6, starred versus unstarred topics should drive your study plan. 7, non-foundational subjects will appear, but the law is always provided. 8, grading is criterion-based, not relative. 9, the digital platform matters. Get comfortable with it. 10, score portability survives, but check your jurisdiction's timeline. And 11, the exam tests 4 skill groups, not just knowledge. And if you take one thing away from this episode, let it be this. The NextGen bar exam is asking you to demonstrate that you can function as a competent beginning lawyer. That's a higher bar than just showing you memorized rules. But it's also, in many ways, a more authentic test of whether you're ready to practice. The good news is that the NCBE has made a ton of free resources available. Go download the official examinee's guide, read the content scope outline, all of it, work through the constructed response guide, and do the sample questions on the NCBE website. These are your primary source materials, and they're free. I'll link to everything in the show notes. You've got this. You've worked too hard and come too far to let a format change throw you off. Know what's coming, prepare strategically, and walk into that testing center ready to show them what you can do. Good luck out there. We're rooting for you. Thank you so much for watching. Be sure to give us a like, leave us a comment, and subscribe so you don't miss any future content. You can also learn more about our NextGen resources at barexamtoolbox.com.